Good evening, everybody. My name is Edith Zeller. I'm Administrative Judge in Austria and President of the European-wide Association of Administrative Judges. Last time we have briefly talked about separation of powers and its relevance for administrative judiciary. To say it in a nutshell, it's the three state powers, legislative branch, executive branch and judiciary, which need to control each other. The system of checks and balances, which needs to be in balance. Today, let us spotlight some practical issues, some practical questions on how to detect that the system is not in balance anymore. The system is imbalanced. The checks and balance system does not work. What are the focal points in the practice to realize that the system is not in balance? We have to keep in mind that the checks and balance mechanisms, which are relevant to stop a person or a group of persons to exercise too much power. So this is the issue, and not so that one group or one branch does not get too powerful. This is a meaning behind. So when do we face a problem? Because of insufficient checks and balances of the legislative branch, of the executive branch and judiciary vis-a-vis each other. When is it the case, practically spoken? The executive power, like governments or ministries, should not exercise legislative powers. This is sure. Laws which are binding on all citizens should not be made by the executive power. For instance, the legislator passes a law which, for instance, passes a law on opening hours of shopping malls, but does not lay down any criteria, but says, well, further details and all criteria should be made by regulation passed by the minister. This means that the minister would make de facto the law passed in a regulation, and this would be a clear imbalance, and this would be also a violation of the separation of powers principle, because de facto it would be the minister, it would be the executive power which determines de facto the legislation. This is a sort of imbalance. For example, some imbalances between the executive power and judiciary. For instance, there is an imbalance when judges who adjudicate in a certain area of law would also be included in and participate in the assessment procedure for passing the law, for the bill. During the process in the parliament, maybe as an expert, the judge would be included to give the expertise and later on adjudicates in the same area of law. This would be a clear imbalance and a violation of the separation of powers. And or another big issue of imbalance and violation of fundamental rights is also the practice that the executive power does not execute final and binding judgments. Here, the judge can adjudicate what he or she thinks is correct, gives a judgment, pronounces a judgment, the judgment becomes final and binding. What happens? Nothing. Which means the executive power ignores the judgment. This is really a problem, a violation of fundamental rights of Article 6 of the Convention, but also an imbalance of the separation of powers. Because this was practiced also in Turkey the years before 2016, the coup d'etat took place. And we see a clear example, for instance, now in Poland, when the judgments of the Court of Justice of the European Union are simply ignored by the Polish authorities, by the Polish executive power, and do not execute the binding judgments. This is a problem. Another imbalance is between the executive power, for instance, and judiciary. Some certain focal points of the judicial structures, like judicial appointments or disciplinary proceedings against judges. What do I mean by saying though? Some concrete examples, namely, when the executive power has determining influence on who will be the one controlling them, who will be the next judge, who will be a future judge. This is a problem, for sure, that's clear. In this case, this would not only violate the independence of justice, but also bring an imbalance of the separation of powers. Because for sure it will be likely to have submissive and willful judges when you have decisive influence on the appointment procedure. And to have such judges at the hand makes it easy to govern a country, I would say. So the Polish situation right now is a good example for this, because in Poland the Polish Judicial Council has decisive influence on the new judicial appointments of new judges. However, the judges of the Judicial Council are handpicked by the Polish Parliament, which means probably influence on the appointment proceedings by the legislative power. For instance, in Austria, in administrative judiciaries, we have here the legislation that the competent committee of judges of the court can make a proposal for new appointments to the executive power. However, by law, for the first instance administrative courts, the executive power is not bound by the proposals of the judicial committees. This weakness can bring with it also an imbalance of the state powers and endanger also judicial independence, for sure. This always goes hand in hand. You can imagine that also the questions who initiates and who leads disciplinary proceedings against judges is equally sensitive and equally important to take note about which state power has which influence. And these are only some few examples on practical problems where we could face weaknesses, where we face proper imbalance, which has also an effect on independence of judiciaries. And next time we would like to sort out what can we do? What can we do to keep it in balance? And what can we do to bring it back to balance? Thank you very much.